green to North Carolina's pines. They walk those miles with hope still in their minds. With every step, the pain was hard to bear, yet through the tears, they chose to persevere. In Tennessee, they felt the river's cold embrace. Their spirit strong, no hardship could erase. The land of ancestors fading in their view, but their hearts held firm, love for what they knew. On the trail of tears where sorrow met the land, they carried dreams within a calloused hand. In Oklahoma, they found strength in pain, survived the journey through the snow and rain.
Very humbled to speak at this conference. I'm sure people saw that in the brochure and thought, why is a sheriff speaking at the, are they expecting trouble? But that's not it. We're going to talk about the Jack Walker murder. It's something that I wrote about it about 17 years ago, and you know, when you write something, people start thinking you know something about it. And so we've done some more research and found some more things out about it. I enjoy this because this is one of those stories and historical events that not only took place close to where I live and involved some of my own county, but I get to put on my historian hat and my law enforcement hat, because we will go back and try to reconstruct, even go to the crime scene or where we think it occurred at. So let's see if I can make this work. Look there. So this is all about this case, and it did have some consequences as far as the removal goes. I wanted to, you probably can't read that. Those are just some significant court decisions that took place prior to the removal. The first one is Cornett versus Winton's lease. Judge John Catron and the Tennessee Supreme Court, and that, I'll ask you to remember that name, John Catron, decided in favor of the Cherokees. Blair versus Pathfiller's lease, Tennessee Supreme Court, it's 1830. Again, Judge John Catron decided upheld Cherokee property rights. And then in 1823 was Holland versus Peck, and that's Judge Haywood, who also, he says the Cherokees are yet an independent nation, subject to laws made by themselves. And so there were court cases, even in the American judicial system, that underscored the sovereignty of the Cherokees to have their own government, have their own court system. So that's going to come into play as we move forward here. That's just another one. Let's move on to kind of get this going. So Jack Walker, he's born about 1800 at Watchawee on the Hiwassee River. He's the son of Major John Walker that we talked about yesterday, as most of you know. There in Calhoun, founded Calhoun, named Calhoun after John C. Calhoun. The community has been known as Walker's Ferry. He had obtained that property as part of his reservation for the Treaty of 1817. Operated a ferry and a grist mill, laid out the streets of Calhoun, and that's where Union County was founded. Once the legislation was passed in 1819, they met at John Walker's home in March of 1820 and elected all of the constitutional officers, first sheriff, the county court. He was on the county court, so he was one of our founding fathers of McMinn County. His son, Jack, though, is they say he was a good-looking guy. He was mixed blood. They were both descendants of Nancy Ward. In 1824, Jack marries Emily Meggs, but he also kept a Cherokee wife, Nancy Bushyhead. As you know, that was not uncommon for them at the time. He would later build a spacious log home, and I'll show you a picture of that in just a minute, that stood directly across from Walmart up in Cleveland. And you know, the Cherokees like to build close to Walmart. So, who wouldn't? So it was directly across the road from present-day Walmart on Highway 11, and there is a Tennessee historical marker marking that site. He was described as a fancy dresser and quite a handsome guy. There is a picture, if you can barely see it, of the home and the home when it was being torn down. That's what the site looks today, looking north, and his house is kind of set in that general area where that tire store is, right there in present-day Cleveland. So there was a little rub between Jack Walker and James Foreman preceding the actual murder. In December of 1825, Jack was a Cherokee civil officer, and he somehow found out that there was going to be an illicit shipment of liquor on the Conestoga River, and he intercepted that and took it from James Foreman, who was, where's she at? There you are. Was running some illicit liquor, and he took it from Foreman. And supposedly the story goes that when Foreman asked him by what authority that he could do that, that Jack pulled his coat back and patted his pistol and said, "By this authority, by God." And so from that point on, they were not best of friends. And so they already had a little bit of a feud between them. Along with Foreman, his half-brother Addison Springston, and all these guys were mixed bloods. And then Foreman later becomes a sheriff in the Cherokee government. So Jack makes several trips. He and his father both were proponents of the removal party, as many mixed bloods were. In 1823, he goes to Washington with James Starr to meet with President Jackson. Of course, the rumors came back to the Cherokee Nation that they had signed all the land away. They had not. But you know what that did for the other Cherokees. That fired them up, and they were already calling for him to be killed. They go back in 1833, the following year. Back in 1834, they visit with Jackson for a third time. This time he goes with David Vann. But neither Ross nor Major Ridge ever endorsed any of these trips. They always kind of felt like, according to some of the things that they said and wrote, that Walker was sort of trying to satisfy his own, and this is just their opinion, that he was satisfying his own needs and his own ends by making those trips. But it was giving him, as you might imagine, a bit of a bad reputation. So you can bear, well, it's the next slide. Walker, in 1834, in August, we have the council at Red Clay. I'm sure many of you are familiar with, where the real divide came between the Treaty Party and the Removal Party. So Jack is there. He's there with a companion from Athens, Tennessee, Richard Dick Jackson. And Foreman addresses the council. He makes some threats toward the removal party. Tensions rise. Walker and Jackson leave early because they seem, according to Dick Jackson's testimony later, Walker felt like his life was in danger. And they don't go straight back to Walker's home, where I was describing to you in present-day Cleveland. They take a circuit down through Georgia to get back to Walker's home. And that's, if you can see that, the pin is where Red Clay is. So they go south, down toward Dalton, and over toward, they stop at Vans, present-day Chatsworth, and they go north on the old Federal. We used to think that they came up 411 and literally passed by McNair's, but the court testimony says, and Dick Jackson's statements say that they left Vans and went toward McNair's. And so they went north, but probably turned on the Spring Place Road just inside Georgia and headed up into Tennessee. And about midway between the state line and Cleveland up there, that's where this crime happens. And I did not do a very good job. You won't be able to see that. That's fine. So, according to the later testimony and statements that were made by Jackson and some others, Dick Jackson and some others, they were riding, they had left the old Federal, they were riding up Spring Place Road, sort of northwest toward Walker's home, and they passed Muskrat Springs. And as they're passing Muskrat Springs, someone yelled and asked if they had any tobacco. And Walker said, yes, I have some. And he turned his horse and rode over to Muskrat's place, and Jackson stays in the road. And then Walker rides back to him after he makes the exchange of tobacco, and he tells Dick Jackson, I felt like those men were going to kill me. So they turned and began riding again, and Jackson stayed later about a mile north of Muskrat's place, Muskrat Springs. Someone stepped from behind a tree and fired a shot out of a rifle gun. We think it was one shot that struck Walker in the left chest and knocked him off his horse. So they were able to immediately identify the two men that came from behind the tree and shot Walker as James Foreman and Addison Springston. They immediately picked up and fled. Walker survived the initial gunshot, although he was shot through probably the upper lung. And he was able to get back on his horse and ride all the way back to his home, which I measured that about 14 miles. So yeah, he either was a glutton for punishment or he was really, really tough. I'm gonna say he was really tough. So he makes that journey on his horse. Now, this is what I think is the crime scene. So when you drive Spring Place today, you pass by the old Muskrat Springs area, which is called Cedar Springs today. And I'm going up through there and I hit my odometer, and I'm going to go about a mile, see what I see. This is a couple of years ago, so I drive on up the way there. And the road more or less follows the original trace, except for when you get to this little dog leg that kind of bears off to the right there, Show Court Road. And I looked at it on the map, and it's clearly a curve in the old Spring Place Road that they just took out later, and when they straightened it. Well, lo and behold, when you get to Show Road, you are a mile from Muskrat's place. And there's a pretty good curve right there. Of course, the topography I'm sure has changed. That is actually looking at the curve, that picture on the right. But I think just based on what those statements were, and all of them agree, that's pretty close to about where Walker was shot at. So Jackson and Walker go back to his home. He does survive, but he eventually dies there about midway through September. He lived about a little over a week or two. But he suffers about 2 weeks, and they bury him behind his home. I will tell you, we don't know where his grave is. His home has only since been removed. He had a sizable DAR marker at his grave. I'll show you a picture of that in a little bit, but it was lost whenever Highway 11 was widened, and that grave is so far we don't really know where it is. So a coroner's inquest was called, and that's what we did years ago when a crime occurred. The sheriff and the coroner, whether it was the county or the Cherokee, they would, that's part of the court system, the way the process worked. They gathered a group of men, and they went to the scene of an alleged crime, and they looked at the crime scene. They did identify some shoe prints that had fled the scene in the direction they saw Foreman and Springston running. And they, based on Jackson's testimony and some statements that Walker made, it was pretty evident that they had their assailants identified, and so some warrants are issued out of McMinn County because it was the closest county to the Cherokee Nation. Bradley County and Hamilton, of course, did not exist at the time. They issued warrants for them. Major Walker actually plotted to kill John Ross after his son died. The words were, he lurked about Ross's place, and Ross had to employ guards because he was in fear of his life that old man Walker was going to do something to him. And if you know anything about old man Walker, it wasn't beyond him to stab a man. He actually tried to kill our first sheriff, Spencer Beavers, when Spencer went and tried to repossess a prize stud from him. And he was a fairly old man and got in a knife fight with Spencer Beavers, who was a cripple, by the way. And so old man Walker was not, he was probably, if I was John Ross and I heard that old man Walker was out lurking about, I'd have some guards too, because he would kill a guy. And so there was a lot of this is a big deal among the Cherokee. So the investigation progresses, the case progresses. Foreman and Springston are arrested by Spencer Beavers, our first sheriff. He transports them back to Athens. Our jail at the time, we actually did a downtown tour for a group this morning and walked right by the old jail site there in Athens. That's now in Knight Park. That's Knight Park. It's a picture of Knight Park. The old jail is actually at the other end of it, down there back toward the downtown area. They were incarcerated there, but then they escape and go back to the Cherokee Nation. There is wanted notifications put out in the newspaper for their arrest, $50 reward for these two. And they were rearrested and brought back and put on trial there in late 1834. So their defense was, they were represented by a noted attorney, Spencer Jarnigan, who would later be one of the founders of Memphis, of the city of Memphis. Attorney Jarnigan's defense was that those two men were this: we're not going to deny that a murder occurred. We're not going to deny that a crime occurred. But it occurred in the Cherokee Nation, not in the state of Tennessee. And so this court, Honorable Judge Charles Fleming Keith, we would ask that it be dismissed on the grounds that we're in the wrong jurisdiction. We cannot be charged by Tennessee or the United States courts. The Cherokees have their own courts and their own constitution, and that's, if there is a case, then that's where these two men should be charged. Based on some of the previous rulings, including those by Judge John Catron in the Tennessee Supreme Court that we've already seen, Charles Fleming Keith, the judge, decides in favor of that plea and dismisses the case and remands it back to the Cherokee Nation. But Samuel Frazier was the district attorney in the case, and he felt like it still needed to be tried in a state court because it was a capital crime. So he petitions and appeals the case to the Tennessee Supreme Court. And so it's meeting the very following year, the following summer, up in Knoxville. Now there are 3 justices that are sitting on the court that day: Justice Peck, Justice Green, and Judge John Catron. Now I've already told you, whose side did John Catron always decide on? The Cherokees. He was always very pro-Native American in those cases. And so they appear in Knoxville before him, before this case, and before this panel of judges. They hear the case, they hear the appeal. Catron writes a lengthy deciding opinion with Gree agreeing and Peck dissenting. And Catron, who had always agreed and always supported the claims of the Native Americans, specifically Cherokee, used language such as, in this case, Catron refers to the Indians as savage beasts in heathen lands, that the principle declared in the 5th century as the laws of Christendom, that discovery gave title to assume sovereignty over and to govern the unconverted natives. Neither our theory nor practice has ever allowed to the Indians any political right extending beyond our pleasure. So what he was saying was, from the time of European discovery, that all Native Americans lost their sovereignty. And that conquest was given down through the ages to the next possessor of that particular property, whether it was another nation or the United States of America or the state of Tennessee or McMinn County, and basically said, you have no rights. This can't go back to the Cherokee courts. They don't have there's no sovereignty granted to them because of this decision he makes. Now, our federal government don't do a lot, guys, unless they have something legal to stand on. And this gave some legality, it took away a lot of the legality and the rights of the Cherokee people, this particular court case. So he opined that they're not sovereign, have no government, no legal system, and so they recommend the case be remanded back to McMinn County. and be retried in Tennessee courts. But it never is. Remember, this is summer of 1835. The removal agreement was signed that November. And there is a past judge of the appellate court of Tennessee, who was actually was in McMinn County. He's since passed away, Ted Brown, who co-wrote a history of the Tennessee Supreme Court, and he kind of turned me on to this case during his lifetime and in his writings. And he sort of draws the conclusion, and I think he's correct, that the Cherokees realized they didn't have any legal grounds anymore because of this case in the Tennessee Supreme Court. And that encouraged the signing of the willingness, how reluctant it may have been, to sign the removal agreement. Actually, it was in December, they signed it down in New Echota. And so the Trail of Tears begins. And I'm not going to overplay this. This was not the cause of the removal taking place, the Trail of Tears. Troy and I have spoken together on different causes, and his presentation is just fascinating. All the different things that just came together that allowed this thing to happen. But this is just one of those consequences of this case. So a lot of people, you might be asking, why did Catherine all of a sudden change his mind? If this guy had always decided throughout a lengthy legal career on the bench, especially as a Tennessee Supreme Court justice, what changed his mind? Well, this is Ted Brown's quote. He says, Catherine viewed the case as providing opportunity to facilitate the success of President Andrew Jackson's popular removal policy at a crucial time during pending treaty negotiations with the Cherokee. That's his summary. That he did it to allow Jackson to get his way and remove the Cherokees. So what was the connection? Well, get this. On Jackson's last day in office, March the 3rd of 1836, guess who his last nomination to the U.S. Supreme Court was? John Catherine. Catherine he was a fine Christian. He supported slavery, sided with the majority in the Dred Scott decision. He only had one child, fathered with a relationship with a slave. He served in the Supreme Court until his death during the last year of the Civil War. So not the best human being ever, but you kind of see what the dirty tit-for-tat was, the quid pro quo, if you will, that Jackson got what he wanted, but he rewarded Catherine. And it was well known that Catherine wanted to be a Supreme Court justice. A lot of people, when I do this program, actually I used to not have this slide in here, but when I take questions at the end, this always comes up. Where's Mary at? Where's the grave? And like I said in the beginning, we really don't know. The house was demolished in 1909. Another home was built there for a while, and it was taken down. And now it's a sort of there's shops and parking lot in that particular area, tire store, a little mini mall. There was a gravestone that was there. That's the picture of you can barely see it up here. It was a big 6-foot tall marker that had a plaque in the middle of it, and that's the DAR marking that.
5 tons.
I'm sorry?
It weighed 5 tons.
Weighed 5 tons, Debbie says. I don't doubt it. It was a big old thing, but it was taken down, and so we really aren't sure where exactly Walker's buried at. But that's kind of sad because he was a significant person, a significant family. This case is very significant as far as the removal goes, and all we really have, at least we have a state historical sign there, but it is very sad anytime we lose a grave, especially a significant grave of someone that we want to remember. So that's really it. Yes, ma'am. Yeah, ma'am. Oh, Melissa.
So, a little addendum to that is that Laura and Darlene and I contacted a grave douser, and we went all over that area behind the tire store, And he did find a male grave, but then he also found additional graves. So it wasn't the only one there, but it is covered up with concrete from the tire store in the back.
Okay.
We asked the manager, could we, they were all out there watching it since we were doing it, but,
You weirdos.
so.
That's great, that's great. Well, there's a good possibility you might have found it then, because those things do work.
Would you ever put a sign marking the ambush site?
I mean, I suppose somebody could, it's on a public road there in Bradley County. Again, that's just Joe Guy's opinion based on the testimony in the court. As I look at that as a sheriff and somebody that's seen a couple of crime scenes, it would make a good place to jump somebody, so. But no, there are no signs as of yet. Any other questions? Yes?
So his language in that new ruling, the savage beast and the doctrine of discovery, I mean, that's parodying Johnson v. McIntosh, the Supreme Court ruling, which was like, I think it's 1823, I think it was quite a bit earlier. And his earlier ones were, I think, Captain's earlier rulings were before 1823, or right around that. So, I mean, he kind of had some legal justification for his new opinion too.
He probably did. I mean, opinions were turning, but this, according to Brown, he did the research, that Catherine had never necessarily ruled against the Cherokee claims until this case. And then for him to get rewarded.
Yeah, it was a politicized environment. Yeah.
Quote, quote, right there.
Yeah. Yes, ma'am.
This is going to sound like a dumb question, but it says Chief Jack Walker. Was there more than one chief?
That is a dumb question. No, you were exactly right. Sometimes he is referred to as Chief Jack. And he wasn't really a chief, but he was certainly part of the leadership among the removal party. So yeah, you're correct. It's the same guy.
Okay.
Anything else? Well, thank you all.